From the WATE.com Digital Center, answering your legal questions. This is Ask Isaacs. Now, here's Lori Tucker and attorney Greg Isaacs.
Hi, everyone. Good afternoon to you. I'm Lori Tucker, along with our legal analyst, Greg Isaacs. It's always good to see you. I haven't seen you in a couple of weeks.
Lori, it's a pleasure to see you, and congratulations on the new grand addition to the family.
Oh, granddaughter number 3. Thank you so much. And a belated Happy New Year to you and to all of you. Thank you for joining us today. If you've been following this case, as so many people have, you saw the news yesterday. Erika Kirk has filed for a speedy trial in the case against a man accused of assassinating her husband, Charlie Kirk. The crime happening back in September. The Turning Point USA founder was shot to death while speaking at an outdoor event at Utah Valley University in Orem, Utah. The suspect, Tyler Robinson, 22 years old, later arrested and charged with aggravated murder and related offenses. He faces possibly the death penalty, which could even include execution by firing squad where lethal injection is not available. Obviously, this is a huge case. And now we have this new turning point, if you will, in this case, and that is Erika Kirk filing the motion for a speedy trial. So what impact could this have on the case?
Well, it has a lot of impact. The first thing it does is it creates publicity. And it hit all the news cycles yesterday. We're talking about it today. And the defense team in this case have already filed for a motion for change of venue, citing the permeated publicity.
Would that really make a difference, though, in a case this big, no matter where you try it in this country?
One of those cases, it's like the Menendez case. It's like a few that are such 800-pound gorillas. You can run, but you can't hide from the pervasive pretrial publicity. And, it also causes prosecutors and it causes defense lawyers to scratch their heads when they're picking a jury and you're trying to ferret through whether there are some preconceived ideas about the case. Would you want a juror that had not heard of this case? Because you would have to say uninformed or ill-informed would have been a tremendous understatement. But what has happened is a really interesting first shot over the bow by the victims and the prosecution, and that is filing a motion as a victim, Erika Kirk, the widow of Charlie Kirk, for a speedy trial.
And it's not uncommon to do that, right? In these cases.
It is uncommon.
So
you have a right.
It is uncommon.
No, it's uncommon.
Okay.
You have a right to be heard as a victim. Unless the Utah Victims' Rights Act mirrors the Tennessee Victim Rights Act. And we actually have codified that in our Tennessee Constitution.
Yeah, let's do a comparison
Article 1, Section 35. But here's what, as a victim, you have in Tennessee the constitutional right, in Utah the statutory right to do.
Obviously, the U.S. Constitution guarantees the right to a speedy trial.
But that's for the defendant.
For the defendant.
This is for
the victim.
Victims. So see, this is for. These laws are to protect and give a voice to people sitting on the other side of the room.
And I know you said this is uncommon. In the research I did, I'm not questioning you, but this is interesting. I'd like you to weigh in. Legal experts stated the filing is a common step in murder cases, but serves as a formal reminder that victims in Utah also have rights to a timely resolution.
Well, I disagree, because what you can do is you can be. Let's just go through the litany of what you have a right to do in Utah and in Tennessee. You have the right to confer with prosecutors. Very important, because you want to express your desire as a victim. And there's going to be some very important decisions being made in this prosecution involving Charlie Kirk's, let's just call it what it is, assassination. Utah is a state that has the death penalty. So those are some really significant conversations that they're going to have. Yeah, that's on the table. But you have that right as a victim in Utah and Tennessee to call up and meet with your prosecutor, your district attorney, and tell them, hey, you don't want this case continued time after time after time. You want to be informed, and in terms of a potential plea agreement, here is the parameters, et cetera. You have the right to be free from intimidation and harassment, very important. The right to be present at hearings, and I will tell you that works. Because
How so?
when you're scheduling, if you have a serious case such as a murder case, and the lawyers are looking at their calendars, and the judge is looking at his docket, and under Tennessee, the prosecutor will step out and check with those victims. So they are very much a part of the ongoing process.
Let me ask you this. Robinson, the defendant here, the accused, is scheduled to return to court on February 3rd. When do you think the death penalty aspect will be decided? Whether they're going to go for that?
That's a really interesting, and that's a question that has a lot of weight and a lot of depth, because what you want to do if you're a prosecutor, you want to make a decision that's not precipitous. You want to get the input from the victims. You want to get the preliminary discovery. This is a really unfortunate, horrific case. But, you want to know what brought Robertson there to that rally that day. So I think, they may be wanting to see if there's more to it. But I think after they get their ducks in a row, typically what you see is prosecutors meet with the victim, and they respect their take. So I think you'll see that happening sooner rather than later, but it's typically a product of investigation and the evidence.
Let me read what Erika Kirk's attorney, Jeffrey Neiman, filed last week, accusing Robinson's team of causing, quote, undue and unwarranted delay. And here's what the filing states. Nobody believed in the importance of the U.S. Constitution more than Charlie Kirk. And although the Constitution guarantees criminal defendants many rights, it does not guarantee them the right to cause undue delay.
Well, and that is the buzzword. When you talk about, now, a defendant, citizen accused, has a right to a speedy trial under the U.S. Constitution.
But again, we're talking about the victim.
But here we're talking about the victim. So, Utah, it's a statutory right. Tennessee, it's a constitutional right. But you are entitled to let's listen to these words, prompt disposition without unnecessary delay. And the dynamic, and we've talked about this before, when you have a serious case such as a homicide, a murder case, it's just not the lawyers, prosecutors, and judges. You have a panoply of people involved. You have the medical examiner. You have people in terms of autopsies. One thing, when you don't have much of a defense, like this case, there's not going to be any disputing that Robinson pulled the trigger. Then you want to take a deep dive into his mens rea or his intent. So I would say behind the scenes, what you have is that team of lawyers putting him through a battery of forensic, psychological, and psychiatric testing. I think they're also preparing for a potential capital case, and then you want to uncover whatever mitigating evidence you have, and that's today, Lori. If you do get to a capital sentencing hearing, you can present evidence as to why someone should spare your client's life. But this is some gamesmanship, because even though victims, we talk about crime, but victims and defendants have a very unfortunate symbiotic relationship. In Tennessee in 2022, we had 500,000 crimes. Well, think about that. If you have 500,000 crimes, you have 500,000 victims. And oftentimes the victims aren't heard. But in this case, if you're the defense team, you're saying, we have a right to a fair trial. We have Fifth Amendment, Sixth Amendment rights.
Let's go back to the speedy trial. What is the benefit of speeding things up for the victim?
If you're the
other
victim,
than getting them an answer and getting this thing over with.
I'm kind of, having made my living in the arena.
On the other side.
I'm going to tell you, if you're a victim sometimes, and I represent victims, and I'll say, let's be careful, because, if you want to just put the pedal to the metal and you want to put a tremendous, inordinate amount of pressure on these prosecutors, and they make a mistake, then this case is going to come back. And one thing that you want, two things, if you're a victim, you want justice, however that is defined, and you want closure.
Yeah.
So sometimes putting pressure, and that's what you see when you see the attorneys for Erika Kirk publicly saying, you're stalling, you're stalling, you're stalling. Well, you're also communicating to the judge. You're communicating to the prosecutors. And next time you need a continuance, or my expert isn't available, or it's taking longer than I anticipated, you're going to see them tighten that leash a little bit. You're going to see them want to really structure the deadlines. So the constitutional and the statutory gamemanship is there. What they're trying to do is just make sure this thing is done without, and here's the word, unnecessary delay.
All right. And this also obviously keeping this case out in front, keeping it ahead in the news cycle. And one attorney said, obviously this is the first time the court is hearing directly from Charlie Kirk's widow in a public filing, saying this is a loud and important voice. It's an important voice that is now coming into the judicial proceedings. Going on now into, as the case progresses, the expectation of how Erika Kirk will present herself in court. Obviously, word is she's going to be there every day in a very public presence.
And she has the right to be there every day.
Absolutely.
And she's someone that can speak not only from the voice of a victim, but also someone that has significant political and moral influence. And I think what you're going to see is the more Erika Kirk's presence is felt, you're going to see the lanes kind of tighten and the boundaries for that defense team, because the judge is going to say, all right, you're entitled to a fair trial, but it's not going to take forever. So you need to tell your experts, you need to tell your investigators that they need to be working around the clock, because we're going to balance the constitutional right to a fair trial with the victim's rights for a speedy disposition with no unnecessary delay.
Now, let me ask you this. Do you find it surprising, because this, again, happened back in September, do you find it surprising that Robinson has not yet entered a plea?
That's a little shocking, because normally what you would do is you would be arraigned. That's just a first step where that judge asks if you understand the charges against you, if you have a right to counsel, and there's typically preliminary scheduling. But at that time, it is common in most jurisdictions to enter a plea. So I don't know.
Why do you think he hasn't? What would be the methodology
a lot of times
there?
you might say my client's not competent, but I don't know. It might be something that's kind of idiosyncratic or unique to the Utah criminal justice practice.
Do you think they might be going for the insanity defense? I mean, we talked about psychological
you
tests.
You can't speculate. You don't know, because what we're seeing is a lot of stuff happening behind the scenes. And it's very interesting, too, as Erika Kirk makes her voice known, you got these two parallel trains. The defense filed a motion to ban cameras from the courtroom. So it's a really interesting dichotomy. You've got the victims wanting, attention, wanting pressure, and then you've got the defense team saying, not so fast, we don't want cameras, we don't want this. So I think what you're going to see is the prosecutors and the victims use the First Amendment to their advantage in a big way.
That'll be interesting. Again, Robinson appears in court February 3rd. We perhaps will find out more about how this case is going to proceed. In the meantime, thank you so much for being with us. We appreciate it. Let's talk more. We're going to boil it down in our segment coming up today at 5:30 on 6 News. We hope you'll see you then, and thank you for joining us, as always.
Always a pleasure.